Appeal and Institute for Government. We will have until 6:29 p.m. for this evidence session.
This is what we've got just now. Yeah, okay.
Thank you for attending today and waiting. Could the witnesses please briefly introduce themselves for the record?
I'm Fiona Rutherford. I'm the Chief Executive of Justice, the UK's law reform and human rights charity.
Emma Torr, barrister and co-director of the charity Appeal, the Centre for Criminal Appeals, which represents people who've been convicted of a criminal offence in England and Wales.
Cassia Rowland, Senior Researcher at the Institute for Government and Criminal Justice, Specialist there.
Thank you very much. I think maybe you may need to just move your laptop thing just so we can hear you. It's blocking the mic. Thank you very much. Opposition Minister.
Thank you. Thanks very much for coming. I want to just start with some questions to Fiona and Emma. Am I right in thinking that you were both signatories to the what you might call the Violence Against Women and Girls grouping to the Deputy Prime Minister saying that we shouldn't move forward with these proposals? Is that correct?
That's correct, yep.
I don't know if you heard the evidence this morning with the Victims Commissioner, in which the Victims Commissioner caricaturised that letter as predominantly being a letter on behalf of women and girls that end up as defendants. And when I read a specific part of the letter that said, well, actually, it's also about victims, the Victims Commissioner said I was unfairly kind of representing the letter. I wanted to give you an opportunity both to talk about whether you think, when you were putting your name to that letter, whether you had women and girls as victims as part of your considerations.
I certainly did. I can't speak on behalf of obviously those other organisations, but certainly from my behalf, that's exactly my understanding.
Yeah.
Yes, I would agree with that.
Okay. And then I also want to ask you something else. I don't mean to put you on the spot, but it's kind of in the public domain. You might know that the member for Hull East, he's said publicly online that he understands that some of the organisations that put their name to the letter or wanted to put their name to the letter were put under pressure by either officials, ministers, advisors at the department not to do that or to withdraw their names. Are you familiar with any of that? Has there been anything that you've heard about that in any way, shape or form?
We haven't participated in any of the conversations that may well have happened with or without ministers or officials.
Okay.
So.
Not within my knowledge at all, no.
Thank you. Moving on then to the substance of what you say in the letter, if you wanted to just tell us the couple of points that you think are most important in relation to why you feel, whilst I'm sure you do, as we all do, really care about this issue of backlogs and the experience it's creating for victims, that these reforms in relation to restricting the right to elect and creating a new bench division, reducing the use of jury trials are not the right way forward. Begin with you, Fiona.
Thank you. I mean, we've already just heard from Daniel Flurry in relation to the way in which the magistrates' courts are simply not structurally set up in many different ways. And we know that there are typically 13 days of sitting that magistrates currently undertake on average. There is also only 3 weeks worth of training that they receive. And if we're talking about moving into a situation where the sentencing powers are going to get far higher, that's of, I would say, significant concern. We also know that if there are going to be, if this recruitment that's being talked about is going to be successful, which we all hope that recruitment of magistrates, bearing in mind they've been cut over 50% in the last 20 or 15 or 16 years, we know that those people are going to be highly inexperienced, whether they're the legal advisors or whether they are the magistrates themselves who are making decisions. Also, just to counter what I think was said by the previous panel, the appeals that come from the Magistrates' Court to the Crown Court when there is a concern about conviction or sentence, we know that 40% of those, nearly half, are overturned when it's to do with an appeal against conviction, 47% when it's an appeal against sentence. So I do think there's a question mark about the accuracy of the way in which magistrates are making decisions. We've talked about, or you've heard about diversity in the magistrates, and it's true that magistrates are more diverse than the judiciary, both in terms of gender and in terms of age. But socioeconomically, that's a big gap for both the judiciary and for the magistracy. And when you're looking at, for example, the number of applications that came from magistrates just to become a magistrate, only 3% of those people who applied to become a magistrate are from manual labour jobs, which of course again is not going to be commensurate or replicative of the people that are going through the system. Unrepresented defendants, you've covered that already. That is only going to increase in relation to the legal aid issues that exist. And that is going to mean fundamentally that the defendants who are in those positions, particularly with very difficult cases, that they could be cross-examining their victims. If there is no lawyer to put that barrier in the way, the impact on those victims, I can only imagine, if they're perpetrator, particularly in very difficult cases, is going to be tremendous. We've talked about minority and disproportionality. There's been a fantastic question from the committee earlier on. There is, we know, greater confidence by the public, particularly those minority communities, in jury fairness over and above anything else. The Deputy Prime Minister, you know, has already written this down, found that out from his own research. Racial disproportionality in the criminal justice system is and will continue to be a problem if we do not continue to try and work through that and keep the juries as the clearest and fairest way of doing that.
Okay, thank you. Emma?
Thank you. If I can answer that question in relation to the proposal to reduce the automatic right of appeal from the Magistrates' Court to the Crown Court. I mean, this has been presented as a package of measures to reduce the backlog in the criminal courts, but removing the automatic right of appeal is going to introduce a multi-step process which is only going to increase the workload of the courts, both the magistrates and the Crown Courts. Just to sort of give you a very brief outline of how it works at the moment. At the moment, it's a very simple form. The defendant or the solicitor, whoever can fill it out, that results in a quick rehearing at the Crown Court, and as we've heard before from the previous panel, that works very well. It takes a couple of hours at most, even less for sentence appeals. What the government is proposing within the bill is a multi-layered process which involves consideration of grounds of appeal, articulation of those grounds in an application, consideration of that application by a Crown Court judge with or without a hearing, followed by then a potential remittal to the Magistrates' Court if there is to be a rehearing, if leave is granted. This is not only going to add to the workload of the courts, this is going to add to the workload of criminal solicitors who work under legal aid, who are chronically underfunded and overstretched in capacity. But perhaps one important thing to consider when we're talking about specifically the right of appeal from the Magistrates' Court is that the Law Commission very carefully considered this in their 700-page consultation paper last year, and they took views from a number of different stakeholders. And their independent analysis was that the removal of the automatic right to appeal will increase the workload of the Magistrates' Court and the Crown Court.
Thank you. I just have a question for Cassia from IFG. Thank you very much for the work you've been doing on this. You've been quoted left, right and centre, I think, in Parliament. You obviously had an initial report that you produced and then a second report. It was characterised, for example, by the member for Gloucester, who's here today, into Parliament, your second report, as moving away from your criticism that you now kind of accept the government's modelling and you think that what the government said is accurate. Would you say that you agree with that you think you accept the government's modelling and you think what they've said about what's going to be achieved is accurate and fair and reasonable now?
I think the approach that the MOJ has taken in terms of how they're thinking about the modelling totally makes sense and is very similar to what we did. I just want to make it really clear that our numbers are the same in our first report and our second report. We are looking at the numbers in a slightly different way to the MOJ. So the 19% overall saving in the Crown Court is specifically for the Crown Court. Our figure, that is a kind of 10 to 13% saving, takes into account the increase in demand in magistrates' courts as well, and that's the big part of the difference. So just to clarify that.
Point. Yeah, so you reject the government's central assertion about the time saving. Is that accurate?
I would say that I think there are a lot of uncertainties behind the modelling. Some of that is inevitable because we don't have the available information. I think in particular, the bulk of the savings come from moving cases into the magistrates' courts rather than from the bench division, the judge-only trial element. And I think there are quite substantial questions as to how feasible it is to move that many cases into magistrates' courts if the bill passes, and also in terms of the amount of time that those cases might take once they're in magistrates' courts.
Right, thank you very much, appreciate that.
Thank you. Minister.
Thank you, and I also got questions for the IFG, and I agree. Thank you very much for both of your reports. It's both incredibly helpful, and I think, as you've just acknowledged, and as you acknowledge on page 2 of your supplementary report, there's actually a good deal of consensus both in terms of the merits of the approach, the soundness of that approach, which we in government had externally quality assured based on the available data. But I think you would accept, as we do, that some of the behavioural changes which are likely to flow from a reformed system, as Sir Brian himself said earlier in evidence, are actually quite difficult to model because they're not currently in place.
I think that's absolutely true. We don't know what is likely to happen in terms of plea rates, also in terms of dropped cases. So things like we have a lot of cases being dropped at the moment, partly because of the length of delays, and the modelling makes certain assumptions about how that might change, but there is a lot of uncertainty there. I think what I would say is that there's definitely uncertainty in both directions, but I think what we don't capture, and we can't capture really in modelling in the short to medium term, is the effect of the reforms themselves and the disruption that potentially creates on the system in terms of short-term productivity and performance problems.
And you've made that thesis, and we're, you know, and I think I'll come to that in a moment. I mean, you make the point about the disruption that might be caused by bringing in changes, but you also make the point that, or the assumption that productivity levels can be restored to 2016 levels. That's where we want to get back to. But of course, as we've heard from earlier witnesses from the bar, quite a lot has changed since 2016, not least in particular, something that you rely on, I think is really useful. What's happened to the workforce? We know that we heard that a quarter of publicly funded silks have dropped out of the profession. We know that in other strands of the bar that the attrition rate has been even higher. And indeed, you tell us at page 5 of your report that the shortage of criminal lawyers is a crucial source of the productivity problems in the criminal courts, with 4%, it's over 1,000 cases, of scheduled Crown Court trials in 2024 rescheduled on the day because the prosecution or defence lawyer was absent. I agree with that analysis for what it's worth. It's really helpful. But it's not realistic, even with the massive investment the government is making both in criminal pupilages and legal aid, to suppose that we can address that workforce shortage in anything other than years. It takes years to train up a barrister. It takes years to recruit lots of judges, doesn't it? So do you agree with me that in terms of that major productivity driver that we need to address, it is going to take years before we see that productivity gain?
I think it does need to be a long-term programme. There are some things you can do in the short term, and we have already seen just in the last couple of years there has been an increase in publicly funded criminal barristers receiving legal aid income and so on.
But not in anything like the numbers we would need to address this.
What you would need, but I think also you have to take into account that there are risks on the other side with some of these proposals that would reduce the amount of publicly funded work existing in the system, that potentially you could lose people from the criminal bar. That there's the risk of making things worse. So I think you do also have to balance that.
There's no disagreement between us that we need to drive at greater productivity and we want to get back to a higher target. I think where the disagreement comes is on the air of realism as to how long that is going to take. I think in your original report, you assumed an 18% productivity gain that could be achieved overnight. We simply don't. We think that's years away because of the workforce. And in the meantime, the backlog continues to go up. The conclusion of the IRCC is that investment, productivity gains, and reform are the only ways we get the backlog down. Do you agree with me that productivity and investment alone won't bring down the backlog?
I don't think I necessarily do agree with that. That I think it will take time, but respectfully, I'd also say that the proposals in this bill will also take years. I think there are measures that you can do on the productivity side that will be faster than some of the measures contained in the bill. I think the case coordinator role, for instance, is really fantastic. We're very strongly supportive of that. We're always banging the drum for more back office and admin staff at the IFG. So I think, and I guess I worry as well that some of these reform programmes will move productivity in the wrong direction in a way that may counteract the benefits of the structural reforms.
And quickly, I don't want to hog the microphone, but just in terms of both appeal and justice, can I just understand it? We've had quite a lot of engagement, haven't we, particularly with justice? I know the suggestion that there wasn't engagement with justice or that we could tell you what to think about anything. I think you've been to a number of roundtables in the MOJ, and we've met a number of times. Just to check, though, you're not an organisation that interacts or provides services directly to victims, are you?
We are not a service. We do not do that, no.
And is that the same thing true for appeal as well?
Yes, but you have to understand that
yes, you do provide services to
We provide
victims.
services to individuals who've been wrongfully convicted and unfairly sentenced. So I think you could classify people like Andrew Malkinson and Peter Sullivan as victims because they've suffered horrendous miscarriages of justice. So in that sense, we do.
Thank you so much.
Thank you. Lib Dem spokesperson.
Thank you all for being here. It's very helpful to have your views as part of the evidence gathering today. Can I ask all of you, do any of you share concerns that there is a lower level of legal aid available in the magistrates' courts and the impact that could have with the magistrates hearing cases that carry higher sentences?
Yes, I mean, I referred earlier to the impact that not having or having more litigants in person, which would be the impact of there being fewer lawyers representing defendants in the magistrates' court. I mean, one of the key things, if you're looking at it from a victim's perspective, is that you will get cross-examination directly from the defendant in court. Equally, there's some issues in relation to the way in which appeals will take place at the moment, as Emma has already said. There is a reliance, and possibly the reason why there is only a 1% number of appeals that go from the magistrates to the court. There is a reliance on the lawyers to really lead the way in terms of those appeals. And without a lawyer being present, and of course without there being even the right to be able to appeal directly, you are leaving a whole load of defendants who may well be wrongly convicted or may well got the wrong sentence for the crime that they have committed, floundering. I simply don't know from what we know about either the legislation or the process, the policy that sits around it, who is going to inform these people of how they're going to put grounds of appeal together, what even are grounds of appeal, how do you formulate those, what are the key points that you need to make in them in order to persuade a Crown Court judge sitting alone in a room with just some papers of evidence. How are you going to put your best case forward? So I think there are a number of ramifications as a result of legal aid being an issue in the magistrates' court, or there not being enough legal aid.
Thank you. And a question for Emma with regards to appeals, and excuse my ignorance, but my understanding is that if you are appealing from a magistrate's court, you do have to have grounds for appeal already anyway. You can't just say, well, I didn't like that, I'd like to appeal and go up to the Crown Court. There is already a threshold that has to be met. Is that correct?
There's a simple form where you have to set out your reasons for appealing. But there's no judge at the Crown Court who's looking at that form and saying you're not entitled to an appeal because you haven't set out what the reasons are that you want to appeal. It's an automatic right to a full rehearing in the Crown Court. And I think that's why it's so important to have, because that automatic right acts as an essential counterbalance. At the Magistrates' Court, we've heard about sort of swift and speedy justice. It is often rough and ready. We're talking about cases being tried by lay justices, some who may be experienced, some who might not be, and we're also talking about less experienced judges. You often find that in the lower court, in the Magistrates' Court, you have advocates who perhaps are more inexperienced. They tend to be people who are at the start of their career, and the more serious the case, the more experienced you are, the more serious case you deal with. So what I'm trying to say, in effect, is that having sort of rough and ready justice dealt with in a very, very quick way, the Magistrates' Court requires that automatic right to redress any mistakes that might have happened. And if I can sort of put it this way, the automatic right of appeal is the yin to the magistrate's yang. It's in the sense that you have an important safeguard against miscarriages happening, and they do. It's worth pointing out that the Magistrates Association, in their response to the Law Commission's consultation paper, they agreed with retaining the automatic right of appeal on the basis that justice may occasionally result in rough edges and potential errors in the Magistrates' Court, and in their view, the automatic right of appeal operated as a crucial safeguard, and that's essentially what we're saying.
Thank you. And a quick question for Cassia. The government proposals rely on the Magistrates' Court taking on a significant amount of additional work and, importantly, additional sentencing powers as well. Can you outline whether you believe the government has adequately outlined how this will be mitigated in the magistrates, and what assessment have you made about how much quicker they'll be able to hear cases compared to in the Crown Court?
So we haven't done a kind of in-depth assessment of the, if by mitigation you're thinking about the kind of the judicial or justice fairness outcome, we have been focused principally on the ability of the courts to cope with that. But I think there are, as Emma mentioned, there is an acceptance that summary justice is rapid justice, and sometimes it is a bit rough around the edges. And so I think there does need to be a clear-eyed assessment of the trade-off you're potentially making between swifter justice by hearing more cases in magistrates' courts and a kind of more robust justice in the Crown Court.
Thank you.
I do one more question, sorry, Chair, and then I'll move on. Has the IFG ever done any modelling around the efficiency savings that could be made by introducing the Rasso courts or in the Labour manifesto, or by other reforms to the criminal justice system, such as introducing AM and PM sitting days in that way?
We haven't. Regarding the specialist Rasso courts, I think that the principal arguments for those are not about efficiency, they are about the experience of the victim and the kind of more trauma-informed and wraparound approach that kind of setup would allow for.
Thank you very much. Alex McIntyre.
Thank you, Chair. Emma and Fiona, I'm going to direct these questions at you, and I'll try to bring them together, even though they're slightly different subjects, if I may. Emma, I'm glad you raised the case of Andrew Malcolm. Obviously, that was a shocking miscarriage of justice. I think just important to note that obviously that was a jury trial at the Crown Court, as I understand it, and there was the right to appeal from the Crown Court. There is a process you need to follow to go to the Court of Appeal, where somebody considers the grounds and whether you have that right. I'm assuming that it's not appeal's position to remove that process either. And we had evidence earlier from victims who supported this right of, well, the change to the right of appeal from the magistrates, so there being a review of it by a judge, on the basis that a number of victims drop out of the process because they fear being re-traumatised by a system that isn't designed to support them. How do you balance that with your position that there needs to be a checks and balance? And do you not agree that by having a judge looking at it, you're not refusing a right of appeal, you're just qualifying it first? And Fiona, Justice has said that the magistrates are ill-equipped, and you've made that point again today, to enable the reforms. But the Magistrates Association, who aren't here to give evidence today, have said the magistrates are ready and willing to play their part. Why does your assessment differ from those of the magistrates themselves?
First, yes.
We already know that the numbers are obviously not where they need to be in relation to the number of magistrates that would be required given the huge amount of work that would be placed into their hands. Equally, we haven't heard yet, and maybe there are plans about this, how the magistrates are going to be better trained in order to be able to cope with the greater complexity of cases that they are necessarily going to hear. In terms of I've talked about the disproportionality of the magistrates, and in terms of socioeconomic grouping, and I think that's absolutely critical when it comes to public trust. And there is a final point which has just escaped me, which I might let Emma come in and I'll maybe come back. Thank you.
Thank you. That was a good question. I think I'd like to make 2 points, please, in relation to that. So, the case of Andrew Malkinson is I think a good example to consider when we're talking about these changes, because of course that there was a victim in that case. The victim was certain that the right person had gone to prison, but we know, of course, that he spent 17 years in prison for something he didn't do, and at the time, when he appealed, a judge looked at it at the Court of Appeal, and twice he went to the Criminal Cases Review Commission, and twice his case was turned down. So you have an example there where a judge has looked at it and wouldn't have given him.
So should we remove it at that stage? Should we remove it at the Court of Appeal stage as well? Is that the position? Is that appeals position?
No, that's not appeals position.
But if that was the case for Andrew, why not? If I may, just if you're making the point that it's not, it would create an unfairness here. You've just said there's an unfairness at the Court of Appeal stage. Why is it then not your position to remove it at that stage as well? The
answer to that is because we're dealing with two different sets of processes. You're talking about the magistrates' court, where there's more risk of miscarriage of justice happen by the very nature of the system, by the points I've made just before about the nature of who's hearing the case and who is presenting the case. But perhaps the most important thing in the magistrates' court is unrepresented defendants. 50% of people in the magistrates' court, around that figure, don't have access to legal advice for their trial, or legal advice to help them with their appeal. And so it's important that you have this automatic right to appeal.
Presumably, sorry if I may, if somebody makes that appeal and they say, I wasn't advised, there's evidence that wasn't considered, I don't think there was a miscarriage of justice here, are you saying that you have no faith in our judges at the Crown Court to say that therefore there should be, or do you think that that's, we're not saying they can't appeal here, we're saying that there would be a check on that, so that if there is a case where they've got no legitimate grounds, and I'm sure you see cases where you go, there's no legitimate grounds, now we're introducing a transcript as well at the magistrates, so people will be able to understand the decision of the magistrates. Do you not think that would lead to an informed process going forward, or do you think that there's just we have no faith in the Crown Court judges to be able to make that decision?
It's not about faith in the Crown Court judges, and I think from appeals experience we receive hundreds of letters from people asking for our assistance, and in the majority of cases they can't articulate in the letter to us, in their communications to us, what necessarily has gone wrong. They will perhaps be concerned about things that have happened during the trial process, but they can't articulate what will amount to grounds of appeal. It takes a lot of care by us to look at the case, to understand what's gone wrong, to analyse it before we can actually decide whether or not we can draw out grounds of appeal. What you'd be asking judges to do is exactly that. Not just read the application and dismiss it because they haven't been able to identify what would be compelling grounds of appeal, but is the judge going to look at the digital case system? Is the judge going to review evidence of witnesses, or are they simply going to look at a short transcript? It's a lot of care that needs to go into that analysis to formulate what could be compelling grounds. And I think giving that job to the Crown Court judge is going to increase the workload.
Order. That brings us to the end of the time allotted for the committee to ask questions. On behalf of the committee, I thank you all for your evidence today. Thank you very much.